Okay. First, thank you very much for attending this class. And I'm going to use a rather different format instead of slideshows because of the answers are easier to be drafted in Microsoft Word. So in this time, I'm going to use Microsoft Word to explain the class to you all. Okay. First and foremost, general paper is a very, how to say, quite easy to pass paper lah, in my personal opinion, because the marks itself, most of it are distributed across into this statement of claim. So if you can draft a reasonable statement of claim, I doubt that you are going to face any difficulty in this paper. But having said so, do not assume that you just draft two statement of claim, namely your tort and also your contract statement of claim, then you are going to pass this examination easily, This is not the case. You are required to answer all questions inside this general paper in order for you to secure a pass for this paper. Okay, so first and foremost, this general paper, you are having a rather generous reading time as compared to the other paper that you're going to sit for. You're going to have reading time of 20 minutes. All right. Having said so, the time itself looks a lot, but in fact, you uh okay. In fact, when we dissect the timings, I okay. If you dissect the timing, actually, the question itself is rather long, and you cannot afford to read it like two, three times, You get me? So your reading speed must be in accordance to the limited time provided. You cannot spend too much time reading and understanding the question and then neglect that you are required to actually write down the answer. That is very important. And many people are facing challenges when they answer this general paper is that they know the answers, but they just do not have the sufficient time to complete the answers. And as a result, you are going to fail for this paper. I'm very serious. Okay. So how do we actually learn the techniques to answer general paper? First, we do not look at the facts of the question. We go to the question directly. Okay, this is number one trick. So at the very first beginning, when you took your paper, isn't it? The first thing that you should do is go and understand what are the question required you to do. So this is just a retrospective way, like a detective, You have to read the question first. Subsequently, what you are going to do is you are going to relate the facts with the question asked. Very important, So you have to really understand what the examiners want you to do. So the first one is to advise Tua as to whether there was an enforceable agreement between CLP and BPP. This is your first question A. And you have question B here. That is, okay, assuming liability can be established against BPP. Advise CLP as to what remedies can be sought against BPP. So automatically in your mind, you are going to name CLP as plaintiff and probably BPP as the defendant. So this is how the game works. And question C will be always, no mistake at all. You are going to draft a statement of claim. All right. So this is how you are going to do facts finding. After reading the question, Then you go back to the facts of the question, and then subsequently you read it one time and you highlight the important points which is related to your question. This will save you a lot of time and sometimes uh, can secure you a pass lah, a confident pass lah. Okay, I would say. So first question, don't forget, advise Tuan as to whether there was an enforceable agreement between these two parties, CLP and BPP. And second question, what are the remedies available for CLP? So we are going to read the question. I hope you have the question with you, because it's very important, you know. Okay, first part of the question, you can see, usually the question will be drafted in a way similar to the way how you draft your statement of claim. They will start with the introduction of the parties, namely who are the defendant and who are the plaintiff and how they are related, what nexus or what kind of relationship they have that contribute to some sort of liability, contractual liability to be exact. All right, you get me? So first paragraph, usually first paragraph will be introduction. Okay, so now you know, okay, every keywords is very important. Do not neglect and omit small details because examiners they are looking at this thing, you know. And uh, actually in practice also, we cannot afford to lose out one single alphabet. If we do lose out, sometimes even if we get judgment, the judgment will be defective, you know, at the end of the day. So this is extremely important. Okay, I'm going to read the question to you, and I hope you can flip through these question papers as I read. As I read along, so that you can follow what I'm telling you. Okay, so I'm going to zoom a bit. Okay, you can see the slides, right? Okay, so CLP Sendirian Berhad. First keyword here, the parties, okay? Highlight. This is a private limited company, okay? So it's based in Ipoh and has successfully completed the development of several housing schemes in Ipoh since 1980s. CLP wishes to expand its housing development business into Klang Valley. So this is how the story starts. CLP has identified a piece of land with area of 400 acres in Puchong, known as Lot 111, 1111 lah, okay, Mukim Puchong, district of Petaling, Selangor. So you have the place, probably this is related to where the cause of action have arise. So subsequently, they put in bracket the Puchong land. So this is the subject matter of the contract. You get me? The subject matter. That means to say, what is this contract about? It's about a land already. You have a clue here. So the registered owner, the Puchong land, is BTP Sendirian Berhad. Again, must highlight this word. This is your potential defendant already. Okay, so BPP is what? BPP itself is an investment holding company having its registered address at Bukit Damansara, Kuala Lumpur. Okay, also very important because subsequently you are going to use this information in your statement of claim because you have to introduce the party by inserting their registered address. Okay. So what happened? Remember, whenever the question is formulated, they provide you the date, R8. So you must also take precaution. There's always a reason why they put information into the question. Okay. So on 1st of August 2023, Tuan bin Jebat MD, the Managing Director of CLP, Paul Lekir bin Lekil, the Chief Executive Officer of BPP, and informed Lekir that CLP was interested in buying the Puchong land from BPP for the sum of 800 million ringgit. Okay. CLP would then develop the land into a housing scheme. So there is an offer already on behalf of CLP. CLP wanted to buy Puchong land. So this is the first uh, information that you kind of feel that the first element of the contract is fulfilled. There's a proposal or an offer here. Okay, what happened next? So on behalf of BPP, Lekir informed Tuan that BPP was not interested in selling the Puchong land, but would be open to have a joint venture with CLP to develop the Puchong land as a housing development. Okay, so the second information that you can probably derive from this fact is that the initial offer made by CLP to BPP was not accepted. Okay, was not accepted. Instead, BPP counter offer CLP for another separate joint venture agreement. Okay, so you get me now? Mm. So Tua here immediately agreed to the proposal for a joint venture and informed Lekir that CLP will send a draft joint venture agreement for BPP to review and agree if there were no issues with the draft agreement. So now the position has changed. BPP counter offer. Okay, put in red color. BPP counter offer CLP for a joint venture. And then subsequently, there's a proposal, counter offer, I would say, and there is an acceptance. So at this stage, there's no agreement yet. You must, if those who are newcomers tonight, you can look at my previous class in YouTube. Is about how this contract law works. So there is a YouTube video. You can look at it. Okay, I don't plan to elaborate much. Okay, so at this stage, it's a promise. It's not yet an agreement. There's no terms and condition yet. There is just merely a counter offer and acceptance between the parties. So there's just a promise to do something. Promise, janji, janji saja, tak ada contract lagi tau. Okay, so what happened next? On 10, again, there's the date, very important, because I already told you the dates are there for a reason. So make use of those information. So Tua sent a draft joint venture agreement to Lekil. Okay. The terms of the draft joint venture agreement provided that, okay, so these are the listed terms and conditions. You can briefly go through because subsequently your remedies probably will come out from the terms. What are the terms and conditions of the particular agreement? Okay. So the first point A is CLP will be the developer of the Puchong land. Okay. And B, CLP will be solely responsible for carrying out at its own cost and expenses all aspects of the development, including Roman 1, the planning, designing, managing, constructing, completing, and commissioning of all the properties to be developed on the Puchong land. Roman 2, the subsequent marketing and sale of the properties developed on the Puchong land. And Roman 3, all ancillary activities incidental to, necessary for, and consistent with the development of the Puchong land. And C, in return, what BPP should do for what we call for CLP in terms of executing their contractual obligation. So you start seeing the name of BPP at the term number C. Okay, so BPP will execute a power of attorney. Power of attorney here usually refer to the land matter is like a surat kuasa wakil. Okay, it's like you act on behalf me legally lah. Okay, over the Puchong land to allow CLP to make all necessary applications for approval, license, and sales of the units to be developed on the Puchong land. And D, BPP's entitlement under the joint venture will be 30%. So BPP will get 30% of the profits obtained from the development of the Puchong land. And E, payments of BPP's entitlement will be as follow. So this is talking about the payment terms already. How should BPP's punya 30% here to be paid? Because the whole project probably worth about 8 million and above lah. Usually 8 million because the purchase price of this land is already we are looking at 8 million. So probably we are looking at maybe double or triple to 2,000 million or the cost like that. Okay, the project itself. So E Roman 1, an initial payment of 50 million will be made upon signing of the joint venture agreement. So the balance payment will be made after the completion of the sales of all units developed on the Puchong land. And the sum constituting the balance payment will be 30% based on the final audit done by an auditing firm to be jointly appointed by parties. And such sum will be paid into account the initial payment of 50 million within 14 days of the issuance of the audit report. So on 11 August 2023, so what happened after CLP had sent the initial draft of joint venture agreement? So Lekia, on behalf of BPP, called up Tua and said to Tua, so thank you for your letter dated, okay, 10 August 2023, and the draft joint venture agreement. So they have duly received the so-called preliminary draft of the joint venture agreement. So on behalf of BPP, we can agree, see, these are the keywords already. We can agree to the terms of the draft joint venture agreement provided you agree to pay an initial payment of 75 million instead of the proposed 50 million. So BPP on its part wanted to secure more initial payment, okay, on his side. Okay. So this one, that means to say the draft joint agreement was not final yet, you get me? So BPP wanted to vary the terms of the preliminary joint venture agreement sent by CLP. Get the clue, because you need to see when the exact date did this joint venture agreement is ultimately formed. Okay, very important. So during the phone conversation, Tua immediately agreed to pay BPP 75 million, okay, as initial payment, and told Lekia that he will be sending the final version of joint venture agreement to BPP for signature. So at this moment of time, okay, when there is no more negotiation, there's no more discussion, as in both parties are well aware and agree with the terms laid down in the joint venture agreement. 75 million is the final say already. Other terms we maintain. So at this moment of time, you can confidently pronounce that the contract has been formed because consideration are there already, capacity are there already, and then intention to form legal relationship, etc., are all there already. Okay, so this had happened on 11. Okay, 11 very important 11 August 2023. Okay, so what happened next? The parties have not yet signed the agreement. You all agree with me, Parties talk over the phone, they already agree with all the terms, and then it's just a formality left out in this part. It's just the signature was not being signed, and then the company seal has not been handed down to the final agreement. So on 13 August 2023, Tua sent the final version of joint venture agreement to BPP for signature and obtained an acknowledgement of receipt from BPP. Okay, so you can get what I mean, because initial draft was not approved by the BPP, 75 million issue. Okay, so 13 August, 2 days after the discussion, Tua sent a final version, okay, to BPP for signature. Okay, so unfortunately, something happened lah. This is normally the case. So on 15 August 2023, what happened? Legia suddenly called up Tua and said to Tua, I regret to inform you that BPP has just agreed to sell Puchong land to another company. You see or not? So therefore, we will not be signing the joint venture agreement that you have sent to us. Okay. So suddenly, BPP wanted to pull themselves out from this deal. Okay. So Lakia then terminated the call. Tua tried to call Lakir back, but all his calls went to voicemail. Probably Lakir had blocked this Tua already lah. So Tua sent a text message to Lakir in the following terms. I tried to call you several times, but you did not pick up the calls. I'm very disappointed that you chose to sell the Puchong land despite agreeing to have a joint venture with CLP to develop the Puchong land. I shall be consulting my lawyers to take action against you and BPP. Okay, so Lakia did not actually reply or respond to this text message. So this one is very important because it served like a notice before commencement of a legal action. Okay. So on 25th of August 2023, Tua came to your law office and informed you that CLP wished to take action against BPP. He also said that CLP had incurred the following sums as expenditure in anticipation of the housing development project on the Ochong land. So these are all special damage already, as you can see. So on 13 August, paid 3 million for legal fees, stamp duty, and associated expenses to obtain a breaching loan financing of 700 million for the housing development project on the Puchong land. Okay. So on 8 August 2023, paid 20,000 to CLP's lawyers for drafting the joint venture agreement. So on 5th August, paid 50,000 to CLP's valuers, RHZ valuers, to provide a valuation report for the gross development value of the housing development project on the Puchong land. And on 14 August, enter into a consultancy agreement with PDA Architects, BAE Engineering, and QS Quantity Surveyors for services to be rendered for the housing development project on the Puchong land. The fees to be paid to this consultant will be based on a percentage of the total project cost, okay, of the housing development project on the Puchong land. The total fees here estimated to be 5 million. Okay, so these are all figures that you must take down in highlight because you're going to answer your question B. If you can still remember, what are the remedies? These are all the money claimable by the plaintiff. Okay, in this case, CLP Sendirian Berhad. Okay, so we go, you all can understand this question. This question, I think, rather easy, for this year. I mean, the facts of the question is quite easy, but the questions are not quite challenging, lah. Okay, quite challenging in my personal opinion. So, first question, we are to advise Tua as to whether there was an enforceable agreement. The keywords here is whether there is an enforceable agreement between CLP and BPP. Okay, so how do you go by this? Okay, the way to answer will be varied from one individual to another, but you should not miss out the part that I have highlighted in red color. Okay, this is the minimal requirement of your answer. But you will be also evaluated by the way that you draft the answer, because this is how I mean, CLP itself is a rather practical paper whereby you are required to to sort of meet the standard to be a lawyer. Okay, and lawyers, we need to do a lot of typing works, clerical works, submission work. So you will need to learn how to draft your story so that you can let third parties, your colleagues, as well as, I mean, the court, as well as the clients to understand what you are trying to say. So this is one, how to say, advocacy skill that you must have. Okay, and you must do it by a lot of training. Okay, so I will put it this way. In view of the complexity of the event, Tua shall be advised to follow the event's timeline in chronological order. Okay, so this is because the story a lot, isn't it? And I mean, you cannot copy every single facts down, and then you'll miss out the point. So you have to conceptualize the what we call the facts given to you into some sort of easier and also legally sensible manner. Okay. So first and foremost, because the parties were being introduced already. So as you all know, they are what? They are Sendirian Berhad and private limited companies, isn't it? So first and foremost, you must examine the talking parties, the parties that who are negotiating the joint venture agreement have legal authority or legal capacity to do so or not. So, because I cannot, is if let's say I'm just a very small position person, cleaner, okay, with due respect, lah, cleaner of CLP Sendirian Berhad, I cannot negotiate a so-called joint venture agreement, isn't it, with other company on behalf of this company. You get me? So, capacity is something that you can briefly discuss. Okay, so Tua here is what? Is the managing director for CLP Sendirian Berhad, while Lekir is the CEO for CLP Sendirian Berhad. So by virtue of Section 64 of your Companies Act 2016, both of them have legal authority. Okay, highlight this one to enter into a contract on behalf of their companies represented. Just one short sentence to discuss this capacity for the beginning. Okay, now because we told the examiners already that we are going to discuss based on the timeline, isn't it? The chronological manner. So first, actually CLP approached BPP for what? To buy land, isn't it? So you first discuss also in brief sales and purchase agreement of the Puchong land. I will put it this way, the answer. Firstly, the attention is focused on the existence of whether there's a sell and purchase agreement of the Puchong land or not. Because at the very beginning of this story, CLP, through its managing director, Tua approached Lekir CEO of BPP on, you see, I highlight the date, because everything is very important, the date. Okay. Okay, Tuan made a proposal under the meaning of Section 2A. Okay, Section 2A of your Contracts Act 1950 to Lekir to purchase the said land. However, the proposal was allegedly rejected by Lekir as BPP has no interest to sell the land. Instead, Lakia had made a counter offer, okay, see, to form a joint venture relationship, which will be discussed later on. Okay, so therefore, first you have to conclude there is no sales and purchase of land agreement. Okay, never exist. Okay, so next we move to this is the key already. Okay, the key point of our discussion, joint venture agreement. Next, the discussion shall be directed to the question on whether a joint venture agreement, if you want to save time, you can use something like this. Okay. Thereafter, called or known as JVA. Okay, is in existence, legally binding, and or all valid in between the parties or not. Okay, so these are the key already. So, uh, like I have concurred myself just now, I'm going to discuss based on the timeline, isn't it? So I will do the same in my following answer. So on the same date of 1st August, 1st August, the said proposal was made by Tua for purchasing the land. And Tua was given a counter offer by Leke to participate in joint venture agreement for the Puchong land. So you roughly define what is counter offer. So counter offer is when the offeree destroy the original offer by making a new one. So this is exactly what happened. You can use English case. This is also frequently used in our court, high against ranch. Okay. So in this case, Tua immediately accepted the counter offer made by Lekir. So you must say this. So at this stage, a promise was formed between CLP and BPP pursuant to your must put down this one, section 2B of your contract act, because proposal is there, acceptance is there. Okay. So what happened next? On 10 August 2023, Tua sent a draft copy of joint venture agreement to Lekir with terms as stipulated in paragraph A to E in the facts. Okay, so do not copy down because you are going to copy down in your statement of claim. So at this moment of time, ignore those and put it very simple terms. Okay, paragraph A to E as stipulated in the facts. So, however, the said draft was not accepted by Lekir. So this is the fact. And on the next day, see, 11 August 2023, Lekir made a new counter offer to vary the terms of JVA, namely CLP shall agree to pay an initial payment of 75 million instead of the proposed 50 million to BPP. Okay, see, again, this is how it goes. The new counter offer was duly accepted by Tua on 11th of August 2023. So the date where the contract is formed is on 11 August 2023. Okay. So you have to put down the following points as well. Although a formal contract was not readily made, nevertheless, it is very unlikely BPP could rely on subject to formal contract principle to argue on the acceptance issue. Okay. as all the terms were certain, okay, unambiguously drafted and explained to Lucky already. Okay, so this show your understanding already. Okay, the contract was merely of a formality rather than its substance because we are not going to negotiate anything. Okay, both parties need no further negotiation to finalize its term. So you can use one sentence. The same analogy was drawn to the case of Charles Greener, Sendirian Berhad against Lau Bing Hong here. Okay. And on 11th of August, it is appreciated that you have to, this is the bare minimum of your answer. If you feel that the whole answer is too long for you, okay, see, a counter offer was made by Lekir, okay, section 2A, Contract Act. The counter offer was accepted by Dua, therefore forming a promise, okay. The considerations, section 2, subrule D of the agreement was clearly defined as per the terms and also remember a varied term from 50 million to 75 million thing. Okay, that is called varied term. Lah. Okay, so both Lekir and Tua have the legal capacity you discussed in the first paragraph already, to enter into agreement as discussed early. I mean, you can put down the section 10, 11, 12. Normally, they talk about you must achieve more than 18 years old, the age of majority, and you must not be unsound of mind in order, and you must have free will or free consent to enter into this contract. So you put down the relevant section. And both parties were of commercial relationship. Okay, they are doing business, isn't it? They want to develop a housing area probably. So therefore, there was an intention to create a legal relationship. Okay, so both parties were of free consent, and there was nothing on the facts to suggest any factors that could reshape the free will or free mind or free consent, whatever, to enter into a contract pursuant to your section 10, 13, and 14, okay, 1950. And one more very important thing, the subject matter itself and the purpose and the consideration behind this joint venture agreement, there was no identifiable issue of illegality. Okay, so the legality of the contract is okay. That means this agreement, contract ini adalah sah dari segi undang-undang ataupun di sisi undang-undang. So all 7 elements of a contract had been present at this moment. Okay, on 11th of August. Okay, very important, eh? Mm. So we move to next part. What should we say? Because they ask you whether this contract is enforceable or not, man. And you must realize this joint venture agreement eventually was not signed by BPP because BPP had changed their mind, isn't so? So you must put down your way, the planning, how you want to answer this question well. Okay, so in Diamond Peak against Dr. Tweedy here, an oral contract for sale of immovable property is enforceable and valid under our law. Okay, see, but is it related to sale of property? It's not. Correct or not? This is a joint venture agreement. So we have to move to second case here. Okay. In Kyongko, Malaysia, Sendirian Berhad against Eng Sia Hai, the laws recognize oral contract. Okay. Provided provided party concern will be able to prove the existence of such a contract and its validity. Okay. So not all oral contract is enforceable. It's not just a general term. You have to prove it. So you have to advise Tua, isn't it? So how do you make your answer a little bit outshine from your colleague? These are the key already. Okay. So Tua is further advised that the setback of his case was due to an absence of an executed agreement in written form because tak ada sign, tak ada documentary evidence. So tak ada documentary evidence mana kontraknya. The opposing party will surely challenge you in the court. Okay, so it would be a significant challenge to prove an oral agreement in court. Okay, this is the reality lah. So corroborative evidence, such as certainties of the terms of the contract. That's why the para A to E is very important. No? Okay. The date of the contract formation, and you have contemporaneous correspondence evidence because this Tua and Legier have been talking, isn't it? And also probably email or exchanging letters and also draft of the JVC. Sorry, JVA. So these are the evidence that you must produce. Okay. And consistency of the testimonies must be available to support Tua's claim. Okay. And finally, because 10 marks, no need to talk about that much lah. I mean, this is already considered a lot already. Okay. So since all 7 elements to form a valid and enforceable contract pursuant to Section 2H of your Contract Act 1950 are fulfilled in this factual circumstance, an oral agreement. So you have to put down your conclusion, isn't it? Okay. Oral agreement is well recognized in our court. So one final point, don't miss. What is your final standing? What is your legal position? JVA ini boleh dikuasakan atau tidak? This is the question, isn't it? So you have to say that Tua is advised that JVA is in existence, valid, and enforceable. Full stop. Okay? Can follow me so far? Uh, or am I jumping too quick? Can understand? Okay, that's very good. Just forgive my voice. Today a bit sore throat. Not just a bit, a quite serious sore throat. A little bit hoarseness some more. Okay. We go to second question. Assuming the liability can be established against BPP, advise CLP as what remedies can be sought against BPP. Okay, when you look at this question, the award of marks is 25 marks. Okay, you must meet the threshold of the marks. So that means to say this question might be a little bit more complicated than what you assume it just to be. This one, a breach of contract lah. And then certainly it goes to the damage. You talk about special damage, general damage, finish. So you'll leave out a lot of marks. In fact, you might fail for your exam also if you just do so. Okay. So first, again, try to practice on how to write lah. I mean, this will be very helpful because eventually it will come like a instantaneous reflex during examination if you practice to write more. This happened to me because to be honest with you, I did not attend class so I attend online classes, so I have to practice a lot of past year question on my own last time. So if the okay I go back to the answer. If the assumption as such is made, the liability of BPP. Okay, just briefly, because the question did not ask you what is cause of action. Don't just memorize your script answer. Oh, breach of contract this one. Then you have to show, oh, there's a valid contract there's a performance on the defendant and a breach and then plaintiff suffer damage, then you write down unnecessary answer. No need, this is not what they want. You just write down the liability of BPP shall be breach and or anticipatory breach of contract. Because eventually, why I put one word anticipatory breach? Because the I mean the potential defendant here, BPP, did not answer the call. So we are not sure what kind of statement of defense we are going to get from the opposing party. So usually lawyers play very smart. They play chess. They anticipate the other people's the opposing counsel's movement. So I put to be safe lah. I put breach and an all anticipatory breach of the contract. So on prima facie proof, through Lucky, CLP had alleged that it had sold the land to third-party company and no longer intend to sign or perform the JVA. And furthermore, CLP had refused to correspond, BPP has refused to correspond with CLP despite efforts made by Tua to call them. Due to the breaches on the part of BPP, CLP suffer from loss and damage. Okay. So again, you have to let your examiner to know what kind of answer that you are going to point to them. It's just like a root sign. It's just like showing you the direction. Okay, my how to say, when we learn advocacy skills from seniors, this is always the very good approach if you can what we call let the examiners know what are the points that you want to put by putting this sort of heading. Okay, heading. We call this heading or subheading lah. Okay, heading. Okay, heading. Very important, Okay. So the following discussion shall explore the remedies available to CLP in a comprehensive manner. Okay, so that means to say you are going to talk a rather long, you are going to have a long passage of answer. Okay, so put your heading to as in is this a root sign. Okay, so first is about performance. According to Section 40, Contract Act 1950, BPP, as a party to a contract, has refused to perform. This is the case, isn't it? Disable himself from performing his promise in its entirety. So therefore, CLP could be discharged. Okay, very important keywords here. Could be discharged from the performance of its further obligation in this contract. So CLP shall pray to the court for a declaratory order to no longer be bound with JVA and discharged from its performance. Why this one is so important, I put at the very beginning, is that most of the time, if we sue the other party, then the other party will blame us for we are the one that default our responsibility. We are the one that did not execute the obligations. You see or not? Putting faults against each other. This is the beauty of adversarial system lah. So performance very important. So the other party never do. So CLP first remedy, I also don't want to do anymore. Court, please nullify this JVA. Please discharge me from because you remember or not, ABC CLP's responsibility. Okay, you can see it's all there for a reason. Okay, CLP will be developer of Puchong. You see, all these costs and expenses. If you do not have such discharge, you still need to carry on one. Otherwise, how on earth the court will know who had breached the contract? You get me? So very important. So performance is one part, discharge, huh? Where are we? Okay. So remedies related to Puchong land. Second heading. In light of unique geographic, this is of course like my sentence lah. You can draft whatever you want. In the unique geographical location of this Puchong land, CLP shall need to enter a private caveat. Okay, because this is a land, so you have a statutory provision under your national land court whereby you can enter a private caveat so long you have so-called you can satisfy the three stages test, the caveatable interest in the land to prevent or to prohibit further dealings of the land. Okay, very important, okay. Because at the end of the conversation between Legia and Dua, we are not exactly sure whether the land had been already transferred or not. So there's a room for discussion. That's why the 25 marks, I assume so. Okay. So apart from that, CLP may seek equitable remedies. Okay. So this is how you want to do with the land lah. Prohibitory injunction to prohibit the sale of Puchong land to third-party company and specific performance, okay, to compel BPP to execute the JVA. So when you talk about land, you want to develop, you want to stop people from selling, these are all so-called equitable remedies. You do not get exactly dollar and cent, but you rather want these people to do something or not to do something. So this is called equitable remedies. So in comprehensive manner, you have to discuss, okay, what are them? The court shall have authority grant prohibitory injunction, which is provided under your section 50, actually it's 50, 50 to 52, if I'm not mistaken. Okay. Of your Specific Relief Act 1950. Okay. In an urgent basis, CLP shall be required to comply with your Order 29 Rules of Court 2012. So that is your procedural rule to file an urgent, probably if you want ex parte, the one that lasts for 21 days. But usually in practice, we hardly do lah because so many times you need to attend the court. Okay, so usually in uh, in practice, what we do is OS plus affidavit plus certificate of urgency by the solicitors involved. Okay, to get what? Urgent. Okay, urgent inter partes interim prohibitory injunction. Very long name, but this is it. So that means to say, you get one injunction, you call the other party, I mean BPP, to attend the so-called prohibitory injunction hearing as well. And then you get a prohibitory injunction which can last throughout the trial. So you don't usually in practice unless it's super urgent nobody will apply ex parte punya apa nama injunction one because the lifespan is only 21 days and then you have to reapply for an interim injunction. So double cost for yourself. Okay, and also waste a lot of court time. CLP shall urgently serve the cost paper to BPP to show that you know what is happening in this time. Okay. Nevertheless, CLP shall bear the burden of proof. Okay. Whenever you apply for an injunction, the burden is on the party that requests for this particular injunction to satisfy the court why the court should stop person from acting or why the court should ask or compel a person to act the way that you propose to the court. Okay, so injunction is equitable remedy. It is a discretionary order at the hands of the court. So burden is on you, and the criteria are rather strict. Okay, so these are the criteria that you must fulfill. I mean CLP lah, not you. CLP must fulfill. Okay, there must be a serious question be tried. Okay, so in this event, you don't write just serious question to be tried, then you put a full stop. This is not an answer, you know. If you I mean, if you just copy down the legal principle, you will not you will not outshine. Your answer is not so related to the factual circumstance. Try to use one paragraph or two to explain what it is meant by a serious question here. Okay, in this event, the breaches and further transactions of Puchong land are imminent threats to result more loss to CLP. Okay, so these are land matter. If you allow so-called the BPP to sell the land, hey, my whole development project, probably I'm on my way to apply licensing, all the, the quantity surveyor, the subcon architect, all will sue me, So those are the imminent threats that can result more loss to me if I don't get injunction from the court. So this is very serious question. And some more second thing, compensation of damages not adequate. In this event, JVA, the subject matter is land. Anything concerning to land, there's a automatical rebuttable presumption that a land itself is so unique, irreplaceable, and any money come in cannot adequately compensate the party. Okay, so explain a bit. Okay, and C, CLP shall undertake damages incurred to BPP. This is what? This is the CLP must execute a letter of undertaking. Surat kujanji bahawa saya akan memberi ganti rugi kepada BPP sekiranya mahkamah at the end of the day decide in favor of BPP. That means mahkamah feel that the injunction is not actually sensible or necessary in the first place. So you have to compensate the other party. You have to write a surat aku janji, letter of undertaking. And B, balance of hardship is caused to CLP. Indeed, the breaches and the sale of Puchong land had caused hardship on CLP. Okay, and full frank disclosure. And of course, the application shall be made promptly. Okay, very important. So the said principles are laid down in land cases like American Cyanamide, okay, and also Kit Gerard Francis. Okay, if you cannot remember full name, never mind, just write the first part of the case law. So long you are not misleading, it should be all right. Okay. So in legal practice, you have discussed already a private caveat as well as a prohibitory injunction. So which one actually would you prefer? So in legal practice, private caveat over the land, which is a statutory provision inside this national land court, will usually be sufficient to achieve a similar purpose to a prohibitory injunction. Because it seems to me, if you do not put this sentence, your answer is redundant as well as repetitive in nature. Okay. So next, the discussion shall revolve around the issue of specific performance. Remember, we talked about equitable remedies, the injunction we have done. So this part, it is strict law that where the contract breach is for the sale and purchase of the land, there's a rebuttable presumption that compensation is insufficient, i.e., chances of getting a specific performance are good. So this principle is actually laid down inside your section 11 of your SRA. Okay, so have a look, please, section 11. Okay, because subject matter still land. However, however, it is worth noting that specific performance is always subject to the discretion of court. Not always they'll give you one because you are restricting, you are restraining the liberty of the other party. You're forcing one person to do something, So not easy. And additionally, this is a joint venture agreement to develop Puchong land, and it is not sale of land in issue here. This particular specific performance prayer might be taught by Section 20 Sub-Rule 1 of your Specific Relief Act, in which subsection A provides that specific performance could not be granted. Don't copy the whole words. Try to understand the statute and put in association with your fact. Okay, could not be granted to CLP if it could be adequately compensated with monetary award. Okay, so if you think one step further, they are not buying the land. They just want to develop the land, the 400 acres land, to earn money. This is the ultimate goal, isn't it? So why must you get specific performance? You can get damage, right? You can get money, isn't it? So this is the first consideration and first discussion you must not miss lah. And what else is the setback for what we call the equitable remedies, the specific performance? Okay, I will submit one more section. That is subsection G. Due to the large area of Puchong land involving 400 acres, the length of the time for development might be extended over 3 years. You see or not? So this is how you answer back your argument. It is a normal practice. The court will not compel BPP to perform an obligation or duty that lasts longer than 3 years of time. Because court is just a matter, it's just a forum to have a trial of that matter, and hopefully by one single trial, we put a full stop, we put an end to all the dispute. So the court does not provide follow-up surveillance monitoring service, So if you do give and do award specific performance that require constant monitoring and constant efforts to be put out by the parties, it will be very difficult. You will give rise to new dispute. That's why the court don't like. So again, subsection G. So in light of such probabilities, but still, you have to plead lah. Eventually, it's up to the client intention, what they want from you, what they want from the court. So you write down for them, adding on your professional legal advice and opinions, isn't so? So in light of such probabilities, CLP shall be advised to pay for damages, okay, in addition or in lieu of specific performance. Okay, you cannot be so hardcore in just asking for specific. I mati mau dia buat, mau dia sign JVA. Kalau tak, saya tak mau. At the end, you don't get habis, your case habis. So this is not a prudent and reasonable lawyer should act lah. So you must put down section 18 of your Specific Relief Act, and CLP must also apply for damages and specific performance at the same time. That means at the same statement of claim lah, you must put down in addition or alternative way, that is money. Okay, if you don't grant me specific performance, please give me money. This is what you want. And then we go to the next heading, damage. CLP shall be able to claim damages for the economic loss suffered due to the breaches of contract by BPP's default of performance. Okay, there are two headings under the damage: special damage, okay, and also general damage. Special damage refers to damages, okay, damages, that means kerugian already, okay, for the loss suffered in preparation for the performance of the contract, which is also known as wasted expenditure. Okay, that means to say they are claiming reliance loss. Okay, apa-apa yang saya rugi dalam proses membuat JVA ini, ataupun apa-apa resit yang saya sudah bayar untuk JVA ini, all these are claimable. Okay, so in this case, you must highlight what are the facts that constituted to your special damage. That will be, you see, you arrange in a chronological order lah. So on 5th of August, what happened? CLP pay to valuers. How much? 50,000. If you can do in a tabulated form, this will be a preferred way, because statement of claim, we also draft in this tabulated form. Easier to read and easier to understand. Okay, so these are all special damages that you can actually copy down from the facts, and you must put it. Okay, so the said special damage is claimable. Open the receipt and proof of payment by CLP. As discussed earlier, it is suggested that, you see, the contract is actually formed on 11 August, isn't it? So what about the expenses? You see or not, the tricky part of this question is you have to delve deep into the every single details for you to get 25 marks, most of the time, unfortunately to say, you wouldn't get. You'll get 12, you'll get 13. Okay? Because the standard of those examiners marking your paper are extremely high in CLP. Okay? So the expenses prior to the date, such as payment, okay, to CLP lawyer, that's why you put it this one, these two. These two, if I am your opponent, I will dispute, because contract, you said yes, this is oral contract. Probably I agree with you. But what the expenses incur before the contract you want to enforce, you want to make my client to pay, I will challenge that. Okay. So those um claims might be subjected to dispute or challenge by opposing party. That means to say you have read the question. You are not like a robot. You have analyzed. Oh, ini mungkin tak boleh claim lah, boss. I mean, your client lah. Okay, so these are the problems might arrive. Okay, but eventually you still need to help your client, isn't it? However, in terms of remoteness, the claims are within the contemplation of the parties. The things done were in close proximity to the joint venture agreement. Okay, all this here is actually for the purpose to draft the agreement, So it is not a remote claim, therefore claimable. Okay. So next we discuss apa? We discuss general damage. Okay, general damage. Okay, see. So general damage would be CLP loss of profit should the JVA be executed. For example, loss of all the earnings derived from the development project, increment of the apa nama, company's asset, reputation or goodwill from this project, etc. So do not just right? Oh, general damage is something to be assessed by the court. Okay, I also know, but this is not the way that you advise your client, isn't it? You must advise to them, yes, general damage, we do not quantify, we do not put it down in figure, but probably we are looking at what are the future, profits that you are going to get from this project. The because the facts say that this CLP is since 1980 ma. I mean, successfully launched so much of housing project. Must be a lot of intangible assets coming in also from this upcoming project, isn't it? So you must take that into consideration and advise your client accordingly. Okay. So pertaining to the reward of quantum of damage, the court will refer to this is one very important section 74 sub rule 1 of your Contracts Act. Okay, which has been statutorily codified the test of remoteness as laid down in Hadley against Baxendale case. Landmark case, you must remember. Okay, H against B. Okay, there are two categories of losses which are considered as not too remote. Okay, this one you can copy lah. I think most of you have memorized it. First one, first limb, ordinary losses which arise naturally in the course of events and extraordinary causes which arise within the contemplation of the parties. All parties know this loss will arise if breach happen. Okay, so given the factual scenario, BPP is well aware of the purpose of the upcoming profits from JVA. It is likely, okay, so you have to submit, all the claims that you have discussed, special and general damage, okay, shall be allowed by the court. So you have a firm standing. So you are extremely confident with your legal knowledge. Wow, or if I talk to Tua lah, I will say to Tua, don't worry, all your claims are within this H against B punya two limbs, it will be allowed. Then you take the case lor, then you earn your legal fees. Okay. But at the same time, don't forget, CLP should be advised also, you should take some remedial action to mitigate the loss. You cannot make the whole things free flowing. Wow, wow, you think now you can claim goodwill, all that. So you let people criticize you online or failing a project, not getting, but you have to do something also, on your part. Okay, so this principle had been laid down in Kapatasan timber extraction against Chong Fa Sin. So for instance, give a suggestion, please, to your clients. Treat your client like as a real person. So CLP should start looking for other potential land in Puchong area for future development. This is for example, of course, you can give other advices in order to mitigate the loss. Okay, but what I'm trying to say here is do not just regurgitate whatever legal principles that you have memorized without any factual association. Okay, very important. So next heading, interest. CLP could claim interest towards the damage that it suffered. Interests are calculated based on when you get the judgment lah. Okay, so this is provided in your two things you must highlight lah. Order 42, Rule 12, ROC, as well as your practice direction, number 1-2012. Okay, if it is a tortious case, you must mention the section 11 of your CLA. Okay, so the present prescribed rate is 5%, but not always. The court may award up to 8% per annum at their discretion. Okay, and costs. Costs kos atas kuasa what we call dasar guaman lah. That means legal cost incur. Okay, so the court also has discretion to order costs and has full power to determine by whom and what extent the costs are to be paid. For example, if you are looking at 800 millions and above punya claims, that means the court fee sometimes can go up to millions, you know. Okay, so this one you also have to claim on behalf of your client. So the general position is the costs are paid to the uh, winning party. The party that lost the trial will be asked to pay the cost to the winning party. Okay, so what are the factors that were considered by the court is complexity of this case itself, the energy involved, the skill involved, whether this is a lot of new question of law lah, a lot of challenges, a lot of time had been spent through or a lot of weakness, you know. So those are the consideration to award the amount of fault. Okay, so you must put it one word here lah. Don't later your client don't know will claim the cost on you. So should the court rule in favor of CLP, very important, at the end of the trial, okay, CLP will be entitled to the cost aforesaid. Okay, so this is, in my personal opinion, the answer for 25 marks. Okay, any question so far? Are you all still with me actually? Because I feel that most of my class is like many of you are keeping quiet. So I'm not sure whether you are able to, after we discuss enforceable. No, don't. If the question do not invite you to discuss course of action, do not simply discuss. Maybe at the conclusion, we state that it's self-enforceable. No, the question just asks you where to discuss whether there's enforceable agreement or not. So, therefore, I think your attention shall be focused on the elements of a formation of a contract, the seven elements. If you're interested, you can YouTube and see my channel. Okay. Okay, so we finish up with the last question here. Statement of claim. Okay, I teach you one strategy. If you seriously have no time, please, if do not perfect your answer lah, just simply write lah. Okay, statement of claim, please do it well because very easy to score, you know. This one, rather than you write a very complicated and long, lengthy answer for A and B, and you miss out the last question C. So some of my friends they told me that if you have identified the issues all that, you can draft your statement of claim first before you do other question. This is also a good strategy. So first part, hey, in the High Court of Malaya at Kuala Lumpur. Why do we know? How do we know the what we call the location, the local jurisdiction of the court is by referring to the facts. Okay, the defendant, okay, BPP is having a registered office somewhere near Bukit Damansara, which is located in Kuala Lumpur. Therefore, by forum of non-convenience, okay, this is a so-called your civil procedures punya favorite question. Forum of non-convenience means a plaintiff sue a defendant, so make defendant's life difficult, isn't it? Call and invite the defendant to the court. So you must not further complicate the things. You have to choose a court that near to the defendant. All right. So this is why we choose Panama, Kuala Lumpur in the first place. Okay. So Uh, this is what? Yeah, 2024 lah, correct. Okay, so this is the format in the High Court of Malaya at Kuala Lumpur in the Federal Territory of Malaysia. Civil suit number, leave it blank, dash 2024. And please don't forget, there's a between what is it? CLP Sendirian Berhad as plaintiff, okay, and BPP Sendirian Berhad as defendant. Okay, so you have statement of claim here. Okay. So first paragraph always start with introduction of plaintiff. Okay. So how do you introduce? The plaintiff is a registered company. Okay. So you put it, what is the legal entity of the suing party? Whether he or she is an individual, a Malaysian individual, okay, or a corporate. Okay, so you have to introduce. Okay. So I'll put it this way lah. The plaintiff is a registered company under Companies Act 2016 and having its registered address at this one, don't leave it blank lah. Okay. Uh, I will put nombor satu Jalan Laksamana 3,000 lah. Okay. 30,000 Ipoh. Wait, Ipoh, Perak. Okay. So this is the full address. At the material time, the plaintiff has successfully completed the development of several housing schemes in Ipoh since 1980s. This one copied exactly from your facts. No time to think, just copy. The plaintiff wishes to expand its housing development business into Klang Valley. So full introduction. You already said plaintiff is a company entity and what it does, housing. Okay. Uh, so by this sort of introduction, probably you are putting forward a good reputation issue also. Okay. So the defendant, second, okay. The defendant, oh, okay, one more thing, you must put 1.5 spacing. So your answer, I mean, you must put spacing, in statement of claim to show that you are compliant with your order 18 rules of court. Okay, very important. Spacing, okay, yeah, spacing. Put a remark lah, so in case you remember. Okay, spacing, don't jumble up everything, you will lose a lot of marks. Okay. So the defendant is a registered company under Companies Act 2016 and having its registered address at okay, nombor 123, this one I record lah, at Jalan ABC, Bukit Damansara, Kuala Lumpur, Wilayah Persekutuan. So at all material time, defendant is, okay, this one, sorry for the typo, because I just did this question yesterday and today have a glance through one time. So is an investment holding company that owns the land in Puchong. Okay, so again, you put one heading here because it's a good practice, if you do it in practice also, to draft statement of claim. So what is the background? Brief facts, latar belakang. Okay, and third, you said that the defendant is the registered owner of a piece of land which with an area of 400 acres in Puchong, Selangor, known as lot. This one you copy exactly from the fact itself. And then this one don't miss, don't just say the Puchong land, because statement of claim means that you have to specify all the particulars of the fact. So you have to make it in detail, the Puchong land. Okay. So what happened? Also, you must be specific because eventually, how well is your drafting in this statement of claim can decide the fate of your client. You are bound within the four corners of your pleading. Don't forget that. Okay. So on 1st August 2023, Tuan bin Jabat, Managing Director of Plaintiff, call one Lekir bin Lekir the CEO of the defendant. Okay, just copy and draft in a legal manner. It was stated that the plaintiff was interested in buying Puchong land from defendant for the sum of 800 million ringgit. However, the defendant was not keen to sell the Puchong land. Instead, it was defendant who proposed to have a joint venture agreement, JVA, with plaintiff to develop the Puchong land as a housing development. Okay. After some exchange of correspondence and the draft of JVA amongst the parties, plaintiff entered into a contract with defendant on 11 August 2023. Okay, then you can start talking about what are the terms already. Okay, so joint venture agreement, put one heading there, show that you are familiar with the practice, the norms of the practice. So the terms of the JVA are inter alia or among others, lah, whatever you want to put. So you just copy down A to E, okay, A to E, as well as, and then at the material time, you have to put the contract exists legally binding, enforceable, and valid between the parties. So you start your standard format. In compliances with this JVA, plaintiff had duly performed his obligation, such as these are the point already. Okay, you can copy from your facts on 5th of August what plaintiff does. So on 8th of August, what plaintiff does again? Okay, 13th August. Okay, to show that plaintiff is in the position. I want to do the contract already. In fact, I have done my part already. It is the fault of the defendant that do not sign, do not do anything. So you get me? So this is how you draft your statement of claim. So plaintiff had also sent the final version of joint venture agreement to defendant for signature and obtain an acknowledgement receipt from defendant on 13 August 2023. Okay, now you want to put the blames. Okay, in breaches of the said contract or agreement, the defendant had informed plaintiff that it shall sell Puchong land to another company. The defendant had disabled himself and or refused to sign the JVA. So all these facts you have to put forward to the court because subsequently you have to produce evidence. Because remember initially question A, this is an oral agreement. Okay, so what's next? The plaintiff tried to contact defendant but was futile. Okay, call so many times tak angkat kan. So in the last correspondence, plaintiff had informed the intention to commence legal action against defendant. Okay, why I want to put this down is because I don't want the opposing counsel to write something that I am abusing the court process. I want to show that in fact my plaintiff, my client had already warned the defendant that they will consult lawyer and they will take action against you. You are the one that tak ada bunyi, tak ada respond. So something like that. Otherwise, how to say is a adversarial system. Again, it's adversarial system. So we have to play our game very well. Okay, so due to the said breach, the plaintiff was put to loss and damage. So particulars of special damage. So this is my format of drafting. Because we put numerical form. Why is that so? Because the opposing party, they have to specifically aver or deny each of our paragraph in their statement of defense. So even in particular of damage, we don't leave it just like something like this. Which one? I mean, ayo, now pula susah. Yeah, 14. Okay. So 14, um, the other opposing party will say, oh, paragraph 14 related to special damage is denied and avert, okay, in its entirety, something like that, okay? And when you talk about special damage, you just need to highlight what are the particulars, what is the description in a very short form, what have been paid, okay? And please remember to put in numerical format. Do not put something like this. I need 3 million, kan? So many zero, lazy to write. Like that. It's wrong, cannot. You have to put 60 and 0.00 lah if you want. Okay. Usually we will put, okay. And it will come in a final figure. If you seriously you do not have time, teach you one, you put it X, Y, Z. Okay, this will be your calculation amount. Okay, I'm sure the examiners will have compassionate for your I mean your XYZ lah. Okay, that means you try to calculate, but you are run out of time. Okay, and what are your prayers? And the plaintiff claims a declaratory order to discharge plaintiff for further performance of joint venture agreement. So remember one of the remedy that we have pleaded, okay? And B, prohibitory injunction to stop defendant from sale of land to third party company. Okay, so injunction, I forgot to mention, it could be interim injunction, that means it's a temporary injunction, or it could be a perpetual injunction. That means to say this injunction will last forever. Okay, so this is the one that probably you can plead. Okay, and specific performance of defendant to execute the joint venture agreement, okay, and or in lieu of RMXXXX, okay, million, calculated as the total value of the housing development project. This one, I do not have the factual evidence to support me. That's why I put XXX. I'm sure they will understand lah. Okay, so this is in accordance to your section 18 and section 28 of your specific relief act. And special damage, okay, remember I don't write special damages, special damage in the sum of, also you write in a numerical form, okay, 8,070,000 ringgit. General damage, interest, cost, okay, and such further and other relief as this honorable court deems fit and proper to grant, okay. And last but not least is your date. You must specify the date lah. This one, just put the date of your examination lah. No need to take. Okay. And this one, don't miss out your signature. You must sign for it. Okay. And down there's a one line and also solicitors for plaintiff. And this one, don't miss out also. This one you can have far. Okay. So this statement of claim is filed by this is my HQ lah. Okay, the Tuan Chris and partner or solicitors for the plaintiff. This one just memorize a fictitious address or your house address with phone number. That's it. Okay. Can understand, Statement of claim, don't miss out, Okay. Wow, ngam ngam today.